Namaskar and welcome to Sansad Television. I am Vishal Dahiya and you're watching our show Perspective, where we bring you detailed analysis of key national and international issues. Today we're going to talk about the Supreme Court's judgment on EWS Quota. Now, the Supreme Court on Monday upheld by a 3-2 majority the 103rd Amendment to the Constitution, which introduced a 10% reservation for the economically weaker section, or EWS, in admissions to educational institutions and government jobs. Majority verdict by SC bench said that EWS quota is not discriminatory and does not alter the basic structure of the Constitution. Two dissenting judges, CJI Lalit and Justice S. Ravindra Bhat, supported quota for the economically backward, but said that the exclusion of the socially backward sections is not allowed in the Constitution. Now, the petitions which challenged the EWS quota had questioned how the quota could cross the 50% national cap on reservation set by the Supreme Court in 1992 and whether it changed the basic structure of the Constitution. The government, on its part, had argued that the quota would help bring people out of poverty and would not cut into the existing reservation for backward classes or reduce seats for the general category as well. So we'll try and understand what exactly has the Supreme Court said today, and also how will it impact the overall scenario when we are talking about the issue of reservation, and more so specifically the reservation vis-a-vis EWS quota. And for more on this, we're joined by a distinguished panel of experts. Let me first introduce them to you, beginning with Mr. Suresh Chandra is here with me, former Law Secretary with the Government of India. We also have with us Satya Prakash, legal editor with the Tribune, and Mr. Sangram Patnaik, advocate with the Supreme Court, is also joining us. We also have Professor Arvind Mohan, who is joining us from Lucknow. He is the head of the Department of Economics in the University of Lucknow. Welcome to you as well, Professor Mohan. I'll begin with you, Satya, and since all of you are legal luminaries here, looking at various aspects of legal issues, you've been, keeping a tab on all that has been happening on this case. If you could bring us up to speed on what exactly has the Supreme Court's observations been. All of us know that it's a 3-2 majority verdict, but what does the verdict say?
The verdict basically upholds the validity of this law. One. Second, the court has gone beyond that. Beyond that means the court has said it doesn't violate basic structure, doesn't violate equality clause and all. Beyond that, it has said that reservation is just a means, it's not an end. Second, the court is saying that reservation cannot continue for all times to come. And you cannot allow somebody to have vested interest in reservation, and that certain sections which have progressed in the last 75 years since independence, there should be a mechanism to somehow take them out of the quota ambit. Okay. So these are the messages which the Supreme Court is sending. This is notwithstanding the fact that two of the judges, they have said that this law is invalid for simply because it excludes SC, ST and OBC from its ambit. Okay. Let me bring in Mr. Patnaik here as well. Mr. Patnaik, what was the challenge through the petition? Some issues, two points which I referred here, and how have they been answered by the Supreme Court in its verdict?
See, I'll tell you, I'll entirely agree with Mr. Prakash with regard to this aspect. See, two major factors in this judgment. One, which is putting the quotas that all these 75 years we are discussing, debating upon the reservation, why it should continue, why it should not continue. At least after this judgment, there are two things which is very clear, that whether it should continue, whether it is a success or a failure till now, and if it is not, why it should not be discontinued for all the times to come. And of course, suppose reservation has its positive aspect, that yes, you are uplifting the poor and downtrodden section of the society. End of the day, if some section of the society has already benefited, see, initially it started, you would be knowing, because you are yourself is an expert. So initially it started for 10 years with regard to the SC/ST, where the 50% cap is there, but it continued for 75 years. Mind it, reservation is not the bottom line for which we would claim that we are a developed country. It is actually to uplift somebody or some society or some segment of the society that you are having the reservation. After this judgment, where it says it requires a relook, the criteria is to find that yes, he is entitled or he is eligible to get the reservation. So those things, at least Justice Padiwal judgment, I mean the aspect that which he has dealt with, that it requires a relook, it requires a re-examination, and it should not be continued for all the times to come. And, Justice Belan Trivedi also, that, her aspect of her judging that, yes, two unequals, you cannot judge equals, right?
Okay.
Suppose, for example, that why it has been upheld. One is that whether beyond 50%, which is the Indra Sahni's judgment, that you cannot have a reservation. Now it says that, yes, SC/ST is fine, but to create that, that EWS quota, that yes, there is economically backward sections of society, they need that support. So the Supreme Court hold that, yes, they are in a different category. So you would not say that, yes, they have to be within that cap of 50%. So these are the two aspects, according to me, and the landmark aspect of this judgment is the majority part, where I would say that, and certainly I would emphasize upon, that somebody would say reservation is required, somebody would say reservation not required. But certainly, if there is a merit in it, please continue. If there is no merit, kindly discontinue, because a section of the society has already benefited, and some people from that section of the society is actually, reap the benefit, or they have reached to their students. I mean, suppose their children are studying outside. Suppose they are now become the bureaucrats. They are, almost in the highest equivalence of the power. But if they are claiming reservation, there is something wrong in our reservation system. At least that part is clear.
Okay. That's an aspect which we will also dwell upon. But Mr. Chandra, let's go a little bit, take few steps back, and let's try and understand a bit more about the 103rd Amendment, the rationale on the basis of which the amendment was brought, and how does it work on the ground?
Basically, I agree with Satyaprakash ji to some extent that reservation is not the end, it is a means. But reservation, initially, if you see in the Constitution, it was socially backward communities. And it was, till now, it was the view and the constitutionally upheld view that economy was not the criteria. So only those who were socially and educationally backward, those who were untouchables for centuries, they were given the benefit of reservation for their advancement. Later on, after considering into the Article 38, Article 39 and mandate of Article 46, read with the preamble. In Article 38, 39, there is a equal distribution of resources, and 46 speaks about the weaker sections. It doesn't speak about any particular socially, educationally or economical. But if you read the preamble says the justice, economic, political and social. So if you read as a holistic this constitution, then you cannot say that the government doesn't have the power to work or to bring out certain policies for advancement of the economically weaker sections.
Okay.
Now, that having been conceived through Article 103, there were challenges, and challenges were, one of them was that it violates the basic structure of the Constitution, which was laid down in the case Anand Bharti's case. So they have brought down so many criteria. None of the criteria is being violated in that, in this article,
103rd Amendment.
Yes, 103rd Amendment. Now, having said that, another aspect was crossing the 50% mark. So they have said that you are the advanced people, general people you call, are 30%. And 70% are the SC, ST and OBCs. So they are not taking anything out of that. 50% they are taking these 10% out of that 50%. So in a way they have tried to explain that the 50% criteria or the maximum limit, though the Supreme Court has said in number of cases that it is not sacrosanct.
Okay.
And in some of the states, it was even up to 68% or 70%. But still, they have said, they have justified in this judgment, as I have read certain notes, saying that the 10% has been carved out from the 30% of the advanced, socially advanced people. So that way, if you see, it doesn't violate 50% of the maximum limit which has been
the 50% criteria.
Indira Sahani case. So that having been done, I don't see there is any other thing, because now coming to this, coming to other, you know, what you call verdict or whatever is as to whether it should continue, it should not continue. I think it is the prerogative of the government, and it is the policy matter. And in the policy matter, the judges should restrain themselves.
Okay.
They can say, they can express their views.
We'll come to that part as well, Mr. Chandra, because that's a very important aspect of the discussion. We'll come to that in the next round. But Professor Mohan is also with us. Professor Mohan, you know, two very significant thoughts here. One is, as all of us are aware, the social status was the original basis for reservation. Now, the 103rd Amendment talks about economy or economic status being taken into consideration. That's why known as EWS Quota, economically weaker sections. So how do you analyze this aspect, this movement from the social status to the economic status?
I think this is a very interesting development that has happened. Now it's very clear that the basis of reservation, as per Supreme Court judgment, is very clearly social plus economic. I will want to refer to two things. One, this judgment. Two, the Constitution itself. Constitution very clearly had a design where reservation was designed to be self-eliminating. There was a clear timeline mentioned in the original Constitution that during this period, gradually, this has to be phased out. That's part one. This judgment also mentions very clearly that now at least some vested interest reservation shouldn't lead to vested interest. And we have very clearly seen that over a period of time, it has actually developed vested interest. We have seen a process of desanskritization which is happening. Many communities which are taking advantage of reservation, many of them, that expression of that what is termed as desanskritization is already happening. It has political, social, and economic implications all across. We have seen Supreme Court in one of its judgment has been talking about creamy layer. Now, if we are wanting to add new categories for reservation, I think that basic spirit of the Constitution has to be kept in mind, that what is the design, that this will be self-eliminating. One. Two, whatever reservation we have been given till date, what is the evaluation, how it has impacted, and this idea of vested interest. Has reservation already developed some kind of vested interest? What are the challenges that we have not been able to address the issue of creamy layer? If you are adding new categories, at least those who have already taken benefit should gradually move out of the spectrum, so that many other groups, many other socially disadvantaged and now economically disadvantaged people can also take advantage of that. So I think these are certain issues which are not clear from, I have not seen any appropriate evaluation that how reservation, we are already in 75th year of our independence and 72 years of constitution. Now 72 years of constitution, and we don't really know that how it is impacting these kind of things, and we are now adding new categories without understanding that how this idea of vested interest can be protected, how it can be self-eliminating. So those are critical challenges. But certainly, as far as the economic aspect is concerned, this decision will have serious economic implications.
Yes, I'll come back to you, Professor Mohan, but those thoughts there, and you know, going back to what you were saying earlier, Satya, and Mr. Patnaik was also referring to. I'll start with you, Satya, in terms of you know, looking at those crucial aspects which Professor Mohan was pointing to, in terms of certain lacunas which are being you know, exploited by certain vested interests, and something which you know, the judgment also talks about. From here onwards, with the EWS quota being upheld by Supreme Court, 103rd Amendment, you know, the path cleared for it as well, how do you see legally ways to tackle those, lacunas, or ways to tackle those areas where a lot more needs to be done, which were earlier pointed out by Mr. Patnaik also?
Well, it's a very tricky question, and the entire thing has to be understood on a completely different, at a completely different level, in the sense, see, the founding fathers gave us the constitution. Whatever they envisaged and good for the country, they put it down in terms of our constitution. The second is Parliament, which represents the popular will. It tries to give it a particular direction. Depending upon the ground situation, it assesses that situation and accordingly takes a decision. Like in this case, the Parliament decided in its own wisdom that a section of the society is economically backward and that needs to be helped in terms of affirmative action and this reservation. The third is the constitutional statesmanship shown by the Supreme Court judges. Whatever the constitution is and whatever direction Parliament wants to give to the constitution through constitutional amendments, the constitutional statesmanship shown by the judges, it acts as a kind of check, exercising their power of judicial review. They try to see and assess and evaluate and then decide whether it's right or wrong. In this case, they have upheld the validity of this law. And then you get what the direction is.
Okay.
So it's not what the constitution makers wanted, it's not what Parliament wants, or it's not exactly what Supreme Court wants. That's a different thing, that they have a final word, but Parliament still can enact another amendment and undo it or further amend it. So this is a very, very interplay of institutions. And it's very, very complex issue. It's not that simple 2 + 2 = 4. So whatever is happening on the ground, Parliament takes note of it through popular will, and then it amends, and then Supreme Court tries to assess it.
Okay.
But at a different level, since we have this is 75 years of independence, so there has to be a white paper on the entire issues relating to reservation, be it reservation in education, be it reservation in political institutions, be it reservation in government jobs, whether the intended beneficiaries are getting the real benefit, one, and second, as some of the judges have pointed out in their verdict, whether certain sections of the society, they have taken benefit of the reservation and they perhaps don't need it. Some of the judgments previously Supreme Court pointed out that there has to be a reservation, a creamy layer concept has to be introduced to SC/ST reservation, because the judges think that some people within the SC/ST community, they have become creamy layer and they have to be taken out of that, so that the real people who actually need benefit of reservation and affirmative action, they should get it. Another point is, can we reduce reservation over a period of time, decade by decade, and in proportion to that, can we increase affirmative action on the part of the state? So these are issues which need to be debated, discussed. But I would like the government to come out with a white paper on the entire issue, not suggesting at all that reservations should be done away with, because there are sections of the society which actually need it, and they should be supported.
And white paper doesn't mean that intention. White paper is basically taking a stock of the situation.
There is political consensus, wider political consensus, even judicial consensus, that reservation needs to stay at least for the time being. And for the next few decades.
Mr. Patnaik, in your views, how do we tackle these issues? And as Satya was pointing out, there is a lot of interplay involved. So it can't be just one legal stand versus another legal stand. We will have to look at the ground realities also.
See, the realities at one stage, yes, it is fine. But as I stated just a moment before, that yes, there has to be an assessment that yes, because of this reservation, where we have reached after 75 years of independence. I would just be very clear on this. Article 334 recommends that yes, there is a limit for the reservation, that is with regard to the SC/ST. Now, when you started by saying there has to be a time period, giving a reservation, yes, there is a thought process gone into, there is a constitutional debate also, that assembly debate, yes, and our great grandfather of our constitution, I would say that B.R. Ambedkar, he has never thought of that, yes, it has to go for years together, or the centuries together. It started just to say that, yes, some segment of society must get that upliftment or that support, right? Now, nowhere it said, I'm entirely in agreement, Parliament is supreme, it can frame a policy, it can bring a law, bring an amendment, 103rd amendment is there, that is, everybody knows about it. Particularly in this case, once the litmus test let down by the Supreme Court in a constitutional judgment with the case of Anand Bharti, that yes, if these are the parameters and this judgment is passed after going through these tests and the parameters let down in the case of Anand Bharti, there is no dispute, there is no debate, everything is rest now. But at the same time, there are two judges out of the 3 majority judgment where the findings are very, revealing, I must say. Why we should not get into it? Of course, I am not saying the Parliament should not get into it. Yes, of course, the Parliament is supreme. But at the same time, the judicial acumen and the vision of these honorable judges must be looked at in open eyes, not with a closed eyes.
Okay.
And if I just one second more, if we have to follow this judgment and interpret the judgment in the TV studio, that is fine. But the moment it is implemented, the net effect is the common man. See, the glass is half full or the glass is full. The moment the segment of the society has taken the benefit, if they are out, then the other section of society will take that benefit. That's my point.
Okay. Mr. Chandra, these two interplay aspects, from looking at it from the legal point of view, from the judicial point of view as well, and then looking at it from a policy perspective also, from the governance perspective, what's happening on the ground. Would you agree with what Satya was referring to, that perhaps the right time for the government to take a public stock of this particular policy, the reservation policy, which we've been following over the decades?
Yeah, it is not that they are not taking stocks.
I said public stock taking, white paper as Satya was referring to.
I also feel that I am with Mr. Satya, that we should take, full stock of the situation. And apart from that, I would like to add here that these are some of the very sensitive issues. Sometimes you touch upon that, one section of society get offended, alienated, and you have to ensure that also. Perhaps we move, because our constitution is not static. It is it's dynamic, it is moving. And we move in a direction like thesis, then antithesis, then synthesis, and this is also a process of that. If you see the thesis, there was a reservation. Antithesis, some OBCs were also brought in. Thereafter, there was a creamy layer. Then synthesis, this economic EWS reservation. And again, the issue is coming. I don't know to what extent it is relevant of the creamy layer that has been negated by the Supreme Court in Indira Sahni's case. But the question is, to what extent we sitting in here in the studio are not the best judges. Judges are those who are the representative of the people, who represent the sovereign, and they will definitely take a stock, and that is our this debate is also part of that. I think.
Okay.
So,
okay. Indeed, the idea here is to just ignite the public debate, look at what the issues are which have to be looked upon. Let's take a quick concluding comment from Professor Mohan before we bring this discussion to an end. Professor Mohan, how would you like to close the discussion here? Of course, for the time being now, this is an issue which will have a lot of debates and discussions in the times to come.
Just two things. One, this is age of knowledge. 21st century is age of knowledge. Knowledge is going to be the key driver, one of the most important driver for India to grow forward. And that is what has to be kept in mind, that merit certainly is going to be one important issue. Two, I think basic structure of the constitution as envisaged earlier and as it continues to be, one of them is that we have to ensure that vested interest does not get created. And two, that unless you have a system where reservation does benefit those who need it, but gradually it has to be self-eliminating. I think that structure has to come forward, and as is being suggested, a white paper certainly is needed, that how moving forward we are going to take care of this basic structure and how we are going to take care of this engine of knowledge which will take India forward.
Okay, okay, there it is. Thank you so much, Professor Mohan, Mr. Sangram Patnaik, Satya, as well as Mr. Chandra for sharing your views and insight with us and our viewers as our experts were explaining the significance of the decision which has come from the Supreme Court upholding 103rd Amendment of the Constitution, whereby 10% quota for economically weaker section in educational institutions and admissions to educational institutions and government jobs has been given a go-ahead. The bill was passed, the amendment was cleared by the Parliament way back in 2019. We'll keep close watch on all the points related to the issue of reservation. We'll keep on debating this, bringing you the finer elements here. Till then, keep watching Sansad Television. Thank you.